getting a lot of questions from you. And we put them down, and I'm going to literally spend the next few minutes going through some of those questions. If your question is not answered, or if you have questions, you're free to send them to me, and we'll work them into another rant. So I want to make sure you understand a couple of things. Number one, these are general answers. These are not necessarily specific to any fact pattern or to every single transaction. You should always check with your company's attorney if you're not clear, because I'm going to give you some general advice as of today's date. So let me just start in with some of the questions. Number of issues with teams. Obviously, the issues are plentiful because of the sheer number of growth. Advertising certainly is an issue. We're seeing some teams mislead the public to the extent that they think the public thinks that they're actually the independent brokerages. So you need to be very clear in your advertising that you are part of a brokerage and give the broker the space and the time that they need. Number two, obviously broker supervision issues, because the teams sometimes take on a life of their own. But if they're part of a brokerage, then the broker supervision issues can become difficult. Employment issues are becoming a problem. As you have probably heard, there's a lot of information being passed around about who is and who is not an employee. Most agents who sell property with proper licenses and written agreements with their brokerage are considered independent contractors. But unlicensed people who do work on a regular basis, whether it be for the company itself or for the team, may create some type of employment issue. And so there are those issues. And then lastly, and I'm tracking a case from back east where this was a high-end luxury market team, and they had a written agreement. The written agreement has been allegedly breached. A couple of the team members who work with the team leader have now gone off on their own, and there is going to be some significant lawsuit action over the next couple of years. So you want to make sure that if you're going to be part of a team, the broker needs to make sure that there is a team agreement in place, that it is clear in that agreement what the responsibilities are of the broker, of the team leader, and of the various members of the team. The broker needs to be aware of all of the employment-related issues, particularly in California with expanding employer liability for sexual harassment, labor claims, and discrimination issues. And lastly, that all of the advertising comply with the California Department of Real Estate laws. The association has an advertising guideline booklet available. It's free. Go to the association's professional standards tab. You can then scroll down, and there is an advertising guidelines booklet that my law firm wrote for you. It's free if you're a member of the association. It's going to be updated in the near future because the Coming Soon issue has been updated by both the Department of Real Estate and the National Association of Realtors. And as with every question, the answer is usually going to be yes. Couple of issues. Number one, you need to make sure that all of the parties have agreed to use electronic signatures under the Uniform Electronic Transaction Act. There has to be an agreement that electronic signatures can be used in place of wet signatures. Number two, and probably as important, if not more important, is the fact that if you're going to use electronic signatures, absolutely nothing wrong with that. Perfectly acceptable. It's efficient. It saves everybody time. It saves everybody travel expenses, and can expedite matters in a very real way. The trouble is, of course, that you still have to go over the documents with your clients. That if you're going to send something by electronic mail in order to get it signed and sent back to you, you need to have something in your file that shows that you properly went over those documents. If it's the purchase agreement, a listing agreement, you may want to send it in advance, suggest to your client that they call you with any questions, have a phone conversation, confirm it by a written email of some sort to the client indicating that very fact. And then, of course, if it's one of the transfer disclosure documents, such as the TDS, the SBQ, or something along those lines, what you want to do is send them the disclosure advisory form that came out in June of 2018. Read it yourself, have them read it, and then you can answer any questions. You should always obviously make the client fill out and sign the TDS and the SBQ themselves. You should not do that for them. Well, there's some bad news and some good news. About a year or so ago, the California Supreme Court clarified a dual agency case and said that if the brokerage represents both ends of the transaction, even if the seller's agent is not representing the buyer, if the brokerage has a dual agency relationship, then the agents have a dual agency relationship. So that creates a much higher standard for a listing agent who is selling a property through his brokerage, even if it's another agent in the office. The clients need to be made aware of the existence of the dual agency, and of course, everything you do for the client must be in their best interest and must hold their interest primary. The issue isn't whether you can get both ends of the transaction. The issue is what is in the best interest of your client. Trying to get both ends of a transaction has led to a number of problems relative to pocket listings, not presenting offers properly, not allowing properties to be shown. There are all sorts of Department of Real Estate rules as well as ethical responsibilities in that area. So while it's okay to be a dual agent, perfectly acceptable under California law, statistically, it's the number one reason you're going to be sued, because the burden on you to discharge your fiduciary responsibilities is duplicated. Another issue that was recently resolved by the California legislature has to do with confidential information. As a fiduciary, you are required to advise your client of all material information that comes into your possession. They get to make the decision on what is and what is not important. In the Hariki case, the information had to do with a disclosure question, but the Hariki opinion left open the question about confidential information. Information such as the seller's motivation, the seller's financial position, whether or not the seller was selling because of some internal family problem or had some other reason to sell. That information could be very valuable to a buyer who is trying to figure out the best way to strategically make that offer. The question then comes up, if I'm representing both the seller and I'm representing the buyer, how do I deal with that type of confidential financial information? And the California legislature cleaned all that up on January 1st, 2019. A new law went into effect that expands an old law. Under the old law, as you may recall, you do not have to disclose how much a seller will be willing to take or how much a buyer is willing to pay. That has now been expanded, and you do not have to share information about motivation, about what are the reasons that the seller is selling, and information like that. We're going to be covering some of that in some upcoming news articles, going to go into some great detail. So from that standpoint, we've seen some things clarified. I don't have a crystal ball, but it seems to me that in California, we are seeing the legislature willing to expand consumer rights. And of course, anytime consumer rights are expanded, liability is expanded with it. One of the concerns that some of us have is the availability of insurance as it becomes easier to bring claims against any professional, including real estate professionals. Will premiums start going up to the point where it becomes prohibitive to purchase errors and omissions insurance? That issue has come up in California in the past, and certainly that is a concern. As far as liability, it just depends on how the legislature acts and how the judges interpret. There are certainly questions about dual agency, as I've just discussed. There are certainly expanding concerns in the area of property management. Technology questions is going to be creating an impact on the issues of liability, particularly because of the readiness and free flow of information. And of course, you have issues relating to language, discrimination, fair housing, and all of that. So I believe that we'll probably see some expansion and some need for more risk management questioning. The next question is tie into that. What's the status of some new fair housing regulations? They're still being worked on. There are going to be some significant expansions both at the regulatory level through the Department of Fair Housing and Employment, but also the state legislature is looking at a number of issues and is continually expanding the rights of a number of people. We are going to be revising the advertising guidelines booklet that is available at no charge on the Pacific West website. But I wanted to bring your attention to a couple of issues. I would suggest that you read the section that's currently in place. We're going to be expanding it because we've been reading some conversations that have come out of the Department of Real Estate, and we want to make it clear on a couple of issues. Number one, it is not necessarily a violation of either the Code of Ethics, the MLS rules, or the Department of Real Estate regulations to simply put a sign up on a property that says the property is coming soon. You have to have the consent of the seller in order to do that. If you sign a listing agreement, then of course the property has to be placed on hold. Hold means that you are not marketing the property. So simply placing a sign indicating that something is going to come onto the market is probably going to be okay in and of itself. The questions then come up regarding the marketing of those properties. Is the buyer being told to present offers? Is the property being actively marketed despite the fact that in the MLS it is indicated that the property is on hold and is not being marketed? What is really going on from the standpoint of the rights of the seller? Have you carefully explained to that seller all of the different ramifications of not vetting the property properly through the multiple listing service? Again, it requires probably a rant all by itself. Take a look at the advertising guidelines, which should be available in its updated format very, very soon. What was happening, unfortunately, was that some buyer's agents were not filling out the buyer's section of the transfer disclosure statement and then arguing that the transaction could be canceled because the TDS had not been completed. And as you all know, a buyer has 3 to 5 days, depending upon delivery, in order to cancel after they receive a completed transfer disclosure statement. The law changed on January the 1st, 2019. On the assumption that the seller adequately fills out their portion of the transfer disclosure statement, and that is why I think it's important that you give them the disclosure advisory and let them read through what is the necessary actions that they need to take to properly fill that out. And then, assuming that you have properly done your portion as the seller's agent, then you will transmit that. You can do that by mail, which is a 5-day process. You can do that by personal delivery, which is a 3-day process. And now, under the new law, if you have agreed with the other side that documents such as notices can be transmitted through email, you can transmit by email. It's 5 days, but of course the delivery period is cut down because email is virtually instantaneously, and so you would go to the next day. Now, what ends up happening once that's transmitted with the seller side being completed, including the filling out of the AVID form, if that's how you're going to complete out your section, then at that point in time, the 3 to 5 day period will commence. And filling out the buyer side is simply an obligation that the buyer's agent has to that buyer, but will not delay the process any longer. It is probably not a good practice. Your broker is your broker. This is their transaction. This is their listing. If your broker is modifying the language in one of the CAR forms, that may be a mistake, and obviously you need to talk to them about that. If it's simply that you don't like their language, then obviously it may be that your language isn't up to par, and you have to really work through all of that with your broker. The next question is, why is everyone so concerned about agents becoming employees instead of being independent contractors? Does that mean I can have a salary? It depends on the agreement that you have with your broker. There is a case that was decided in 2018 called Dynamex. Dynamex makes a presumption that everyone is an employee unless they meet a test which real estate professionals cannot meet. The test, in part, requires that the independent contractor act in a manner that is not part of the main function of the employer. And of course, as real estate agents, you sell property, which is why the brokerage primarily exists. There is a provision of the Business and Professions Code in B&P Section 10,032 that says that you may elect independent contractor status so long as you have a valid existing license that is hung under the broker's umbrella, that you have a written agreement with your broker, and that the primary source of your income is through commission sales. Why is that important, and why do we not want people to be considered employees? Because California has one of the most complicated employment law setups in the nation. Issues regarding wage and hour, clocking in, obligations to comply with all sorts of different laws regarding minimum wage and family leave and documentation all come into play that don't necessarily exist in an independent contractor status. Additionally, for those of you that are not producing at a level that would justify a salary, you face the real risk that your employer may simply choose to go with more productive people. So there's lots of issues, and frankly, I can see as a lawyer why it would be a mistake to require that real estate agents become employees. That's a legitimate concern. As I indicated in a prior rant, the contingency for sale of the buyer's property is a highly complex document. As a result, many things can go wrong. I would suggest you go back a few rants, take a look at what we said. If you still have questions, I'll be happy to answer them in an upcoming session. And the answer is probably not. If you are also a broker, you can set up your own management arm in whatever manner you deem appropriate. You need to make sure that it's clear at the sales office that you are not acting under that umbrella if your broker does not want to do property management. Many of the contracts have clauses in them that indicates that the brokerage does not do property management. Certainly, there are a myriad of issues relating to that subject matter. It can be very complicated, but the general answer is if you are an agent acting under a broker and your broker does not want to do property management, then you are probably acting inappropriately if you start doing property management without either having a broker do that brokerage qualification for you, or if you go get your own broker's license. Well, the first question is, can a seller or the seller's agent, upon the advice and consent of the seller, can the seller require that an agent submit an offer and have their buyer pre-qualified with a lender of the seller's choice? And the answer is yes. There are a couple of caveats. Number one, you may not require that the buyer use the lender of your choice. That would be a violation of a number of federal and state laws. While you can require pre-qualification by the lender of your choice, or cross-qualification, as that term is sometimes used, you may not require that they use that particular party. Number two, you should not get anything of value for making that referral. We have handled a couple of cases with the Department of Real Estate, and the Department of Real Estate has taken the position that you could be, quote, steering people towards a particular service provider, including in this case a lender, because of getting something of value. And of course, anything that you are doing should be for the purpose of benefiting your client. In a multi-offer environment where you're going to be getting multiple offers, certainly you want to make sure that the offers that you accept are from legitimate buyers. So under both the Code of Ethics, the Department of Real Estate, and the Multiple Listing Service rules, there is no restriction so long as all you're doing is requiring that pre-qualification from the lender of your choice. Under a change that took place to the Code of Ethics, Article 1, Standard of Practice 1-7, you can indicate to that seller's agent that they are in violation of the Code of Ethics. The new standard of practice, which I would urge you to go online at the association and read the Code of Ethics and take a look at a standard of practice 1-7 under Article 1. What it basically says now is that upon the request of the cooperating broker, which is now referred to in California as the buyer's broker, a listing broker must advise the buyer's agent in writing either A, that he has presented the offer to the seller, and that must be in writing, or B, she must provide the buyer's agent with a written proof that the seller has instructed that there not be any further offers presented, or that the offers be presented in a different manner than is typical. That is now a violation of the Code of Ethics to fail to respond to an inquiry. The new change to the residential purchase agreement does seem to imply that that written requirement is made at the time you present the offer, but it would be my suggestion that you do a separate cover email or letter indicating that you would like that reply in writing to be presented to you immediately. Obviously, the purpose of all this is because there have been agents who simply did not submit offers to their sellers, or there were legitimate questions about whether that offer was ever submitted, because many times the seller ends up closing to a transaction where the listing agent also served as the buyer's agent and is double ending the deal, sometimes, frankly, for less money. It is a major issue at a national level, so that's why this is the National Association of Realtors Code of Ethics change. It is a major concern in California, and it is of major concern to the Department of Real Estate, because members of the public have been damaged by that conduct of not adequately presenting offers. So, bottom line, if you don't get a response, hopefully you will contact the association, and either Lori or Janine may make a phone call to the broker of record and see if there is something that can be done to facilitate. If not, we would hope that you would file an ethics violation if that conduct took place after January 1st, 2019. And the answer is, it depends. I'm a lawyer. I'm a risk manager, so yes, I like to see repairs disclosed. But if you're going to use a seller property questionnaire, under the section dealing with repairs and other types of remodels, there is no time frame listed in that SPQ. Therefore, the answer is yes. There is another reason, however. Not all repairs take. Sometimes the seller won't know that a repair took because the situation that led to the repair hasn't come up again. Sometimes many years have gone by and the problem seems to have been rectified, but there are ways that you can make those disclosures without harming your deal. If, for example, there had been a roof leak and the roof leak was repaired. We've had a tremendous amount of rain over this year and, of course, in past years, and if no leaks have occurred since those repairs were done, while you certainly could disclose that the repairs were made, you can also indicate that there have been no additional problems. You can never go wrong with making an adequate disclosure, but if, in fact, another problem comes up where there was a repair, for example, a roof leak comes up or a pool leak, a case I saw recently, you may end up with some situations where the repair didn't take properly, and now you've got the problem all over again. And the cost to have to deal with that, even if you did nothing wrong, certainly begs the question of why the disclosure wasn't made. And again, it depends. Absent fraud. So we're assuming that there was no intentional concealment Maybe it's one of those situations where there was a material fact that probably should have been disclosed. If all you are representing is the seller, then the statute of limitations is generally going to be 2 years from the date of close. If you are representing the buyer, you have a fiduciary duty to the buyer. The statute of limitations is generally going to be 3 years and from the date of discovery. There are other statutes of limitations. If you're a dual agent, probably 3 years from date of discovery. If you are representing someone and there's an alleged fraud or misrepresentation, it's also going to be 3 years. And then there are varying types of statutes. If the statute of limitations is based on some breach of a written contract, it's generally 4 years. 2 years from a verbal agreement, although in your case, because of Article 9, there should be very few verbal agreements. And then lastly, of course, there are some very lengthy statutes of limitations for things like latent defects, which are defects that simply aren't available or readily ascertainable because they're inside walls, under slabs, things of that nature. And that statute is generally 10 years. Oftentimes it's clear that the statute of limitations have run. Oftentimes it's not clear, and it becomes a question of fact and subject to proof one way or the other. It is considered what lawyers call an affirmative defense. Therefore, the burden to prove that the statute of limitations has run and therefore the claim is stale is on the defendant. I believe that's all the time that I have. So we're going to end it now. Obviously, we'll do other rants. If other questions come up, we'll add that to the mix. We're going to be covering some new laws, some new forms, and some other things in future rants. We're going to talk a little bit more in detail about disclosure law. And so hopefully you find these sessions helpful, and I look forward to coming before you again. Thank you very much.